Good evening, my name is DJ Ennis, and welcome to Vote Right for America. In episode 10, I covered the subject of poverty, defined what it is, and informed you that its alleviation is not the responsibility of government, and that, in fact, the government couldn't possibly be the alleviator of poverty. I pointed out that you, me, our churches, faith-based organizations, and other nonprofit organizations are the true alleviators of poverty in the American society. In this episode, I'm going to cover the hot topic of abortion. I'm talking about abortion on demand, not about abortions conducted by physicians to save the life of the mother. As a historical note, when states had abortion laws before the Roe v. Wade ruling, the courts throughout the land always had the backs of physicians who had to make the crucial life and death decisions to save the life of the mother. This was not always codified into law. Some states had it in law, but it didn't need to be. Common sense rulings became precedents and was understood as if it was common law. Common law, as you may know, like common law of contracts, aren't legislative laws per se, but laws historically upheld as matters of common practice with its roots in English common law. The center of the abortion controversy is the 1973 landmark U.S. Supreme Court decision, the case of Roe v. Wade. Justice Harry Blackmun was tasked to write the opinion of the majority of the 7-2 decision. Only Justices William Rehnquist and Byron White dissented. Blackmun was new on the court, and in his own admissions, later as well as documented in his paperwork that is now stored in the Library of Congress, his written decision on the case was among the most emotionally trying he could write. Unfortunately for our nation and the integrity of the court, the decision was riddled with bad information and legal contradictions. Most abortion advocates and people who lean pro-abortion pan the idea about the errors and don't want to get involved with the specifics of them in the decision itself. Before I go into how badly Roe v. Wade was decided by the Supreme Court, I need to address why people who lean left, who tend to be in the egalitarian political economic groups like the Democratic Party, the Socialist Party, and the Communist Party, favor the outcome of Roe v. Wade and why they think abortion on demand is necessary. Historically, the advocacy of abortions before the feminist movement in the 1960s and 1970s came mostly from men. Many of these men believed that population growth around the world was too much. Their view was that the use of contraceptives, with abortion as a backup plan, would help drive the population growth rate downward and help preserve natural resources around the world. Leftist thinking, or egalitarian political economic ideas, hold dear the idea that government should be more controlling on the preservation and use of economic resources, including all resources used by people, that government can fairly distribute resources and control outcomes that's fair and equitable. So it became natural to them to believe that abortion could be part of that plan. In the People's Republic of China, an egalitarian political economic society run by the Chinese Communist Party, there is a family size limit. They have a two-child policy. It was once a one-child policy, but the government economic forecasters concluded that the population level was too low to have sufficient human resources to maintain the Chinese economy in the future. That is, they need more slaves for the state. When a woman in China becomes pregnant, and the pregnancy endangers the two-child limit for her family if the pregnancy comes to term, the woman is obliged to go to the nearest medical facility and have the problem eradicated. If the abortion is not performed and the couple breaks the family size limit, heavy taxes and other punitive actions are imposed on them. In the People's Republic of China, where the government tries to coordinate and control economic resources and outcomes like all other egalitarian political economic societies, abortion is considered a must, a last-ditch effort at controlling people, supposedly in the best interest of society. This is why egalitarian political economic groups like Democrats, Communists, Socialists, and the like want abortions to be legal. At the moment, it's a right. In the future, as they believe people would become desensitized from the evil and sinister nature of the act of abortions, it would help transition abortions from a right to a mandate later on if egalitarian groups manage to attain control of our government. For them, abortion will play a part in people and population control, the control component that is needed for their vision of government. It's part of their inevitable conclusion. Now that you know why abortion is key to the leftist political groups, let's explore the problems with Roe v. Wade and abortion on demand. One of the male influencers for the pro-abortion position was a magazine writer named Lawrence Lader, who authored a book published in 1966 called Abortion, the first authoritative and documented report on the laws and practices governing abortion in the U.S. and around the world, and how, for the sake of women everywhere, they can and must be reformed. That's the full title of the book, a large title for such a narrow-minded book. Sue Ellen Browder, the author of the autobiographical and insightful book on her role in the feminist movement titled Subverted, How I Helped the Sexual Revolution Hijack the Women's Movement, authored an opinion piece recently published in the National Catholic Register titled Who Really Wrote Roe v. Wade? She reveals in her research behind the Roe v. Wade decision that Justice Blackmun and law clerk George Frampton heavily relied on the information in the book by Lawrence Lader to write the court's opinion. In her article, Browder pointed out that Lader's book on abortion was, quote, chock full of historical, social, political, legal, and theological errors, unquote. She credited Joseph Della Penna for debunking Lader's book in the scholarly paper titled The Historical Case Against Roe v. Wade. Della Penna was a retired law professor at Villanova University and author of the 1,283-page volume called Dispelling the Myths of Abortion History. Sue Ellen Browder further noted, quote, for our democracy to function effectively, Americans count on the Supreme Court to base its legal opinions on only the best, most reliable sources. So how could the court have cited this decidedly unreliable book 7 times as a source for the most controversial decision of the 20th century? In Blackmun's, unquote, in Blackmun's opinion for the court, he points out that the 14th Amendment doesn't define what a person is, and that all references to persons in the Constitution are viewed postnatal, people already born. His opinion and the opinion of the majority of the court refused to be swayed by how different states like Wisconsin further identified in their statutes that an unborn child was, quote, a human being from the time of conception until it is born alive, unquote. In Connecticut's then new statute passed in a special session in 1972 declaring that the public policy of the state and the legislature was the intent, quote, to protect and preserve human life from the moment of conception, unquote. Essentially, the court's majority intended to ignore the 10th Amendment power of states, as well as the 14th Amendment itself, to define what human beings were in favor of a nationwide politically motivated conclusion toward an absolute right of women's choice of abortion. Although there are women who assert that this is a right, remember that this is a made-up right that at first appealed more to men than women. The declaration by some women, and certainly not all, that abortion is a right of women, saying, quote, it's a woman's body and the woman has a right to choose, unquote, is in itself a narrow-minded statement. It precludes acknowledging the other person involved, the individual inside with his or her own genetic coding, his or her own nervous system, and his or her own blood type. If it was just about the woman's body, there would be no argument here. But there is someone else involved here. Justice William Rehnquist, in his dissenting opinion, pointed out, to reach its result, the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment. As early as 1821, the first state law dealing directly with abortion was enacted by the Connecticut legislature. By the time of the adoption of the 14th Amendment in 1868, there were at least 36 laws enacted by state or territorial legislatures limiting abortion. While many states have amended or updated their laws, 21 of the states on the books in 1868 remain substantially unchanged to the present time. There apparently was no question concerning the validity of this provision or any of the other state statutes when the 14th Amendment was adopted. The only conclusion possible from this history is that the drafters did not intend to have the 14th Amendment withdraw from the states the power to legislate with respect to this matter. In essence, the U.S. Supreme Court overstepped its bounds of staying with the time-honored jurisprudence of interpreting laws in light of the Constitution based on its historical intent. That's what made Roe v. Wade so unconscionable. Not so much that abortion on demand, supposedly in consultation with a medical practitioner, was made legal, but that states were overpowered by such a reckless legal precedents to protect the least vocal of people. The court even established a first trimester rule, as if legislating from the bench wasn't enough. They now needed to regulate what they legislated to override objections from state legislators. To me, Roe v. Wade was as bad as another Supreme Court decision, Dred Scott versus Sanford, which was decided in 1857, where the court decided that African Americans were not full persons, but property. Carolyn Gargaro, a pro-life advocate and co-founder of Right Girl, in her article, Roe v. Wade, the Unconstitutional Decision, published in February 2000, made the following observation. The 14th Amendment, how ironic. One of the amendments which helped overturn Dred Scott is now used to further the non-person argument, the same argument the amendment was created to prevent. How can the Supreme Court use the 14th Amendment to help justify denying the unborn unalienable rights when this amendment was supposed to protect people from such selective rights attribution? It would seem obvious that the framers of the 14th Amendment implicitly included the unborn child in the due process and equal protection clauses of the 14th Amendment. It's about at this point that someone is bound to jump up and proclaim, this amendment mentions citizens and the unborn isn't a citizen until birth, so this does not apply to the unborn. Not quite, since the 14th Amendment states that the state shall not deprive any person, not just citizens, life, liberty, or property without due process. As a society, we need to consider whether human life has intrinsic value or it does not. For most of us, it's an easy answer. It is yes. This concept doesn't rate high among abortion advocates. They deny that an unborn child is life, just as Palestinians and Hamas leaders in Gaza deny the existence of Israel, although Israel's just a missile lob away. The conclusion of the existence of life is philosophical or abstract. Science doesn't conclude when life begins, but scientific evidence aids us in our inference and conclusions regarding life. What we know is this, that when the sperm penetrates the egg, it forms a blastocyst. The blastocyst becomes an embryo. The embryo becomes a fetus. The fetus becomes an infant. The infant becomes a toddler. Toddler becomes pre-adolescent. The pre-adolescent becomes an adolescent. Adolescent becomes adult. Adult becomes geriatric. This is the morphologic process of a human life. I understand why abortion advocates say things like, we don't know when life begins. The truth of the matter is not only do they not know when life begins, they don't want to know. For them to pinpoint the beginning of life in the morphologic timeline would be damning to their whole argument. So they take philosophical refuge behind, we don't know when life begins. What sucks is they expect the rest of us to cave into their narrow-minded, intellectually dishonest view. You're watching Vote Right for America. Please subscribe to this blog. It's free, and you can also email me with your comments and questions at vrfa.djns@gmail.com. And please comment. I'll use your comments and questions to clear up matters or concerns you have in future episodes. Good evening.